Hey folks, how's it going? This is a belated Supreme Court update. Thought I was done for the season, but the Trump tax cases came out, and as a tax lawyer, I wanted to comment, even though it's a little political, uh, hit you with my usual disclaimer that this is for educational purposes, not legal advice or financial advice, and obviously all opinions are mine and nobody else's. And an extra disclaimer that I'm not getting into the politics here. I'll discuss them, but I'm not taking sides. It's not intended to be advocacy. I'm not trying to influence your vote in any election. And any political opinions of mine are omitted. So anything you think you hear, those are yours. Any opinions you infer, those are your own opinions you're hearing. So the main cases that I'm going to discuss: Trump v. Vance, Trump v. Mazars, and Trump v. Deutsche Bank, which was joined with Mazars. Um, those are about the Manhattan DA subpoenas and a number of House subpoenas for Trump's tax records and financial information. Um, so, just as a general overview, those are the full captions of the cases. And the question is, can a state prosecutor subpoena tax and financial records of a sitting president? Uh, and can the Congress subpoena those same records for a sitting president? Um, so, just to start with Vance, which is the New York case, 2018 investigation by the Manhattan DA, the New York County DA, had included a 2019 subpoena to the accounting firm Mazars. They were trying to get Trump's tax returns and schedules 2011 to present. Um, and so it's a subpoena to his accounting firm. It's not to Trump himself or to the Trump organization. It's to his vendor, his accountant. So they would have records about him that they would be required to submit. Trump sued the DA to block the enforcement of that subpoena, and his argument was that a sitting president has absolute immunity from state criminal subpoenas, but not immunity from state criminal liability. So essentially, just from the subpoenas, the allegation was it's an unnecessary distraction. There's a stigma from a subpoena, and it could lead to harassment if everybody started subpoenaing him, just keeping him busy unfairly, so he couldn't do his job. So the opinion was 7-2, written by Roberts, and pretty famously, if you've seen it in the news, it just said a sitting president doesn't have any special privilege with regard to private records from a subpoena, even a third-party subpoena. And that there's not any sort of heightened protection. President can fulfill his constitutional duties without any special protection from subpoenas. And the president can just use the regular remedies anybody else has to challenge a subpoena. So anybody can challenge one, and the president can use those. There were concurrence from Kavanaugh, joined by Gorsuch, that there needed to be a demonstrated specific need for it. So basically, just a slightly higher standard. Um, but ultimately, they agreed with Roberts and the liberals that the subpoena should go forward. There were dissents separately, Thomas and Alito, and basically just said this would be an undue burden and distraction. The president couldn't do his job. Um, well, what about Mazars? So Mazars, again, which was joined with the Deutsche Bank case because the facts were so similar. Different House committees issued 4 subpoenas to Trump's accountants, again, Mazars USA, and his banks. And they were seeking tax returns, transactions, financial records, etc., for Trump, for the Trump organization, his businesses, and his adult children. Um, so the position of the president and the Department of Justice, the Solicitor General, was executive privilege applies even to the president's private papers. Conversely, the House position was almost, they didn't quite say it this way, but essentially a limitless subpoena power, even over the president's private papers. So the DC District Court and the DC Circuit Court of Appeals both sided with the House and upheld the subpoenas in Mazars and Deutsche Bank, and said that they either, in one case, that they served valid legislative purposes, and in the other that they served valid investigative purposes, and that was enough. So everything's looking good for the House in Mazars and Deutsche Bank. So Supreme Court, what's the Supreme Court's opinion? Well, once again, it's 7-2 Roberts. And their decision was not to decide. It was to remand to the district court to get further consideration on separation of powers. Basically, they said, this is a really important thorny issue, and we want you to think more about it. Try again. Um, Essentially because the president and the House, or Congress generally, want opposite extremes, and the concern uh, from Roberts was essentially that the court could unbalance the branches by wading in, and that this might in fact be a political question which would best be resolved between Congress and the president without regard to the court, and pointed to some other examples where similar disputes of this nature had been solved by those branches without the court, although nothing was quite on point, but similar situations. There were again separate dissents, Thomas and Alito, and for slightly different reasons, they both thought that the subpoenas exceeded the House's power. Thomas had a more sweeping declaration that going after the president's private papers was just generally a bridge too far in most cases, whereas Alito had a little more of a nuance, just you need a really good reason to go after the president's private papers. That's the simplest way to describe, at least my reading of those two dissents. So here's my analysis on both Vance and Mazars and Deutsche Bank. For Vance, I think the reason Trump lost was that the arguments were not narrow. They weren't very well tailored to the subpoena. He came up with subpoena harms and subpoena risks that could apply to anybody. So why exempt only the president? So we got very florid language, very historical minded, sweep of history, the president is not above the law type stuff from Roberts, and that was quoted extensively in the media discussing these outcomes, these Trump tax cases. He was basically coming up with arguments that apply to anybody. It really just wasn't a thoughtful, coherent standard. I'm sure they did the best they could, but I read it and I don't think that it's very coherent. It comes off very self-serving, and that when that's transparent, the court tends to want to side against you. All of the arguments focused on all state subpoenas, not just this particular subpoena. So if they had focused maybe on particular defects of these of the Vance subpoena, they might have been able to get away with it. But focusing on all state subpoenas, it's probably closer to what they want. Maybe they would have gotten a good ruling, but it did rob them of some possible nuance that they could have given the court. They could have let the court have a midway position of maybe a future subpoena would work, but not this one. But unfortunately, by focusing so much on just no state subpoenas, that left the court less room and pushed Roberts, I think, towards more of this no precedence above the law type result. I also think it's interesting that they conceded a criminal investigation by a state or locality, like the Manhattan DA, would be valid, but they wanted immunity from a subpoena. And I think that there's a lot of tension in that position. For Mazars and Deutsche Bank, essentially, I think the court has just avoided controversy. There were two extreme positions, and they decided to just delay, defer, wait until the election's over, not get too far into this thicket. So even though it was often discussed in the media with Robert's language, I think that ultimately the court didn't want to be too bold and just jump right into something, because there are legitimate concerns that they did raise. I think that there was enough reason for that, and they like to be cautious. But I do also think that the court prefers nominal limits, even if they're not actually going to enforce them. They want there to be theoretical limits, both on the executive and the legislative. And to a great extent, the executive, the president, was looking for a very strong exclusion, a very strong privilege. And that's not very limited. And by the same token, the House of Representatives was looking for a very strong subpoena power with not a lot of limits. And the court tends to not like those. But when both sides are unlimited, I think they decided to say try it again. So what about my larger commentary? Obviously, if you're watching any of the media on this, if you saw it, the political outcome is that we won't see Trump's tax returns, which he has not generally released, unlike most prior presidents. Almost all major candidates back to Nixon, post-Nixon, all major presidential candidates released their returns. Trump has not done so for various reasons. And this might have been a way to get them out before the 2020 election, But because of this decision, it's unlikely that it will be resolved, and we'll see those returns before November 2020. But what about the legal outcome? I'm a lawyer. I'm not. I don't want to get too far into the politics. Let's just talk about the law. I think the net position between these cases, between Vance and Mazars, doesn't make a lot of sense to say that the president is not protected from state subpoena and he's just a regular citizen, but maybe he is protected from a House subpoena. That does not seem like a good standard to me. I think that is kind of arbitrary. So I'm skeptical of that. I was also concerned as a tax lawyer that the court didn't grapple with the tax code or its history on this subject, considering these are about tax returns. So, it's very common that tax and ERISA don't get a lot of attention from the court, and when they do, it can be a little abstract and philosophical, and they can have trouble dealing with a lot of the nitty gritty. But it did feel like they didn't even discuss the subject. Um, and that's unfortunate because there's actually a long history of using tax return information. And so here's the current code. Uh, it's called the Code of 1986, but this is still the law. Section 6103 just gives very explicit power for committees to request the information of any return or return information upon request. And then there are some privacy limits elsewhere, and there's some limitations on what they can use it for and when it can be republished, but they can look at it. Pretty broad power. This is, if you go back to 1954, the Code of 1954 has very similar language that they can request any return, and they can republish it to the Senate or the House or both. So all of Congress can see any tax return. I can go back to 1939, the prior version of the code. So we're still in the 1986 code. Previously there was 54, and now if you look at the 1939 code, which was the code before that, they have very similar language, almost exactly what's in the 54 code. And go even further back, the Revenue Act of 1926, as this is before they even called it the Internal Revenue Code, is pretty equivalent language that any committee has the right to inspect any returns in any manner they determine, and that they can republish it, send it to the Senate and the House. And it's even in the Revenue Act of 1924 before that, with pretty similar language to inspect any returns and to pass on useful information to the Senate or the House at large. So there are further uh, further basis for this law if you go further back in history, but it starts to get less and less directly on point. But Congress has been claiming it similar powers, or broadly similar powers, well back into the 19th century, not long after the Civil War. So basically, older than the income tax, Congress has been claiming some kind of power, and very specifically since 1924, as far back as my research allowed, Congress has been giving explicit power to committees to look at any tax return, which makes sense. If they have the power to tax you, they have the power to tax your money. To take your money, why wouldn't they have the power to look at the information? That just makes uh, thematic sense. So, what are the takeaways? Well, so the state criminal subpoena does apply to the president. There's no specified justification, just like a regular citizen. And then the district court is reconsidering the House subpoena because of separation of powers. So that might result in maybe a slightly higher standard or a significantly higher standard, or it might be very similar to Vance and no special standard. So we'll see on that, but we need more time. Ultimately, I'd say if you want to understand how to read this, it would be that the Supreme Court kind of balked. It was politically controversial. They got into it a little bit, but they didn't want to go too far. Politically, the political outcome is that we won't see the Trump tax returns before November. Uh, and speaking as a tax lawyer, the court just kind of skipped the history of tax laws in the US that give explicit power to congressional committees to see tax returns. That's Congress, and even before then, Congress has claimed a lot of power over tax return information to use for oversight and other investigative purposes. So I think that hopefully when we do see more resolution on Mazars and Deutsche Bank, we'll see a little bit more information. I'd love to see that investigated a little more in depth, because it could really if they don't, it could really have some interesting consequences if they try to change those parts of the Internal Revenue Code without grappling with them. So I don't want to get too far into the politics. I hope that this was interesting to you from a legal perspective. I hope that I provided you with some information. And I really do not want to get involved once again in whatever disputes are going on between this side or that side. But I do think that there are some interesting legal issues, and hopefully we'll get a little better outcome in the future that grapples a little more directly with some of these key issues. So thanks for taking the time, and hope you have a good one.